ADR Viva questions. Types of alternate dispute resolution mechanisms. Various alternate dispute resolution mechanisms can be classified as arbitration, conciliation, mediation, judicial settlements inclusive of Lok Adalat, negotiation, arbitration, mediation. Arbitration decides the matter. Mediation, parties select mediator and decide the matter. Arbitration is formal, mediation is informal. Arbitration less expensive than litigation, more expensive than mediation. Mediation less expensive than litigation or arbitration. Arbitration relationships can become strained. Mediation relationships likely to be maintained cordially. Arbitration binding resolution upheld by courts except in very narrow circumstances. Mediation parties participate in the process and shape resolution. If mediated resolution, parties can reject it. Arbitration versus mediation. Mediation is a process where mediator helps the parties involved to negotiate and come to a friendly settlement. Arbitration is a process where an arbitrator decides an outcome of the dispute, focusing on the evidence available and the law presented in arbitration. Mediation has a broader role. Arbitration has comparatively limited role. Arbitrator comes to a binding decision on already submitted dispute. Mediator encourages the parties involved to come up with their own solution. Mediation, comparison, mediation, procedure, objective facilitation, conciliation, active facilitation. Process for solution, mediation, parties involved to find a solution, conciliation, facilitator proposes solutions, authority of the facilitator. Mediation, none, only a role of guidance. In conciliation, yes, too is seen as an authoritative figure. Regulated by CPC Act, mediation is Arbitration Conciliation Act for conciliation. Confidentiality based on trust or confidentiality clause under mediation. Confidentiality is fixed by law in conciliation. Result desired. Agreement is beneficial to the parties in mediation. Settlement agreement beneficial and reasonable to all parties in conciliation. Enforcing of agreement, enforceable by law in mediation, enforceable as a decree of a civil court in case of conciliation. About the term Lok Adalat means people's court and is based on Gandhian principles. As per the Supreme Court, it is an old form of adjudicating system prevalent in ancient India and its validity has not been taken away even in the modern days. It is one of the components of alternative dispute resolution ADR system and delivers informal, cheap, expeditious justice to the common people. The first Lok Adalat camp was organized in Gujarat in 1982 as a voluntary and conciliatory agency without any statutory backing for its decision. In view of the growing popularity over time, it was given statutory status under Legal Service Authority Act 1987. The Act makes provisions relating to organization and functioning of Lok Adalats. Central Government Act, Section 7 in the Arbitration Conciliation Act. Arbitration Agreement. In this part, the arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of relationship, whether contractual or not. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing. Arbitration agreement is in writing if it is contained in a document signed by the parties, an exchange of letters, telex, telegram, or other means of telecommunication which provide a record of the agreement, or an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other party. Section 8 in the Arbitration Conciliation Act. Power to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject of the arbitration agreement shall, if a party so applies not later than when submitting his first statement in the substance of the dispute, refer the parties to arbitration. The application referred to in the subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or duly certified copy thereof. Notwithstanding that an application has been made under subsection 1 and that issue is pending before the judicial authority, an arbitration may be commenced or continued and an arbitral award made. Section 9 in Arbitration Conciliation Act 1996. 9. Interim measures, etc. by the court. A party may, before or during arbitral proceedings or at any time after making of the arbitral award, but before it is enforced in accordance with Section 36, apply to a court for appointment of a guardian for a minor or a person of unsound mind for the purpose of arbitral proceedings or for an interim measure of protection in respect of any of the following matters, namely the preservation, interim custody, or sale of any goods which are the subject matter of the arbitration agreement, securing the amount in dispute in arbitration, the detention, preservation, or inspection of any property or a thing which is the subject matter of the dispute in arbitration, or as to which any question may arise therein, authorizing for any of the aforesaid purposes any person to enter upon any land or building in the possession of any party, authorizing any samples to be taken. Section 10 in the Arbitration Conciliation Act. Number of arbitrators. The parties are free to determine the number of arbitrators provided that such number shall not be an even number. Failing the determination referred to the subsection 1, the arbitral tribunal shall consist of a sole arbitrator. Section 11 is the Arbitration Conciliation Act. 11. Appointment of arbitrators. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. Subject to subsection 6, the parties are free to agree on a procedure for appointing arbitrator or arbitrators, failing any agreement referred to in subsection 2. In an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator, who shall act as the presiding arbitrator. If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from the receipt of request to do so from other party, the 2 appointed arbitrators fail to agree on the 3rd arbitrator within 30 days from the date of their appointment shall be made upon a request. Section 12 in the Arbitration Act. Section 12 grounds for challenge. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances likely to give rise to justifiable doubt as to his independence or impartiality. An arbitrator, from the time of his appointment and throughout the arbitral proceedings, shall without delay disclose to parties in writing any circumstances referred to in subsection 1, unless they have already been informed of them by him. The arbitrator may be challenged only if the circumstances exist that give rise to justifiable doubt as to his independence or impartiality. He does not possess the qualifications agreed to by the parties. A party may challenge an arbitrator appointed by him and in whose appointment he has participated only for. Section 34. Application in setting aside arbitral award. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with the subsection 2 and subsection 3. Arbitral award may be set aside by the court only if the party making an application furnishes proof that a party was under some incapacity, arbitration agreement is not valid under law to which the parties have subjected it, or failing any indication thereon under the law for the time being in force, or the party making the application was not given proper notice of the appointment of arbitrator or of the arbitral proceedings, or was otherwise unable to present this case, or the arbitral award deals with a dispute not contemplated. Who has given the idea of establishment of ombudsman in India? M.C. Satalwat suggested the idea of establishing an ombudsman at an All India Lawyers Conference in 1962. Generally, the ombudsman is to a judge or a lawyer or a high court officer. He investigates the complaints from clients against the administrative and tries to find out the remedies. An ombudsman or his equivalent has become a standard part of the machinery of any modern government in India. And Lokayukta seeks to provide for establishment of a Lokpal for the Union, Lokayukta for states, to inquire into allegations of corruption against certain public functionaries. Why Section 89 inserted in Code of Civil Procedure? Section 18 of CPC gives power to the court to refer the matter to ADR methods when it appears to the court that there exists an element of settlement which may be acceptable to the parties. Then the court may formulate such settlement or propose a tentative settlement and refer the parties to an alternate means of settling the dispute, such as arbitration, conciliation, lok adalat, or mediation.